finally, we see here the imposition of longer investigation time limits for offshore tax affairs for income and inheritance tax, but not for corporation tax, thus privileging those who can incorporate and large multinational corporations. Our Clause 4 attempted to highlight the systematic bias in the current government's approach by contrasting the level of interest that's paid on penalties incurred by tax avoidance promoters as against the interest payable on student loans. Now, many members, I'm sure, will have seen research undertaken by the TUC released yesterday, which highlighted the fact that households are now subject to record levels of debt. That research indicated that, excluding mortgages, average debt per household shot up by £886 last year to a new peak of an average of £15,385. Peculiarly, some appear to have tried to criticise this analysis by pointing out that it includes student loan debt. But surely we should all be deeply concerned by a situation when so many young people are facing such a mountain of debts. And that is what it feels like. And we now have a situation, I'm sure many members here will have heard this from their constituents, that ex-students, former students work incredibly hard all year. They pay in, trying to pay off that loan, and actually it's larger at the end of that year than it was at the beginning because of that interest rate of 6.1%. Let's compare that 6.1% to the current interest rate on late payment of penalties for promoters of tax avoidance schemes. That interest rate, I'm sure members will be interested to hear, is 3.25%. It's essential that the government looks into this carefully. We won't push our amendment on that issue to a vote, but we do hope the government will look into this in much more detail than it has until now. Now, clearly under this government, very often there is one rule for the very best off and another rule for everyone else. And that is also what we see when it comes to the loan charge, which is covered by Amendment NC26. Now, the activities targeted by the loan charge were a form of tax avoidance, but the government's approach to dealing with them has been deeply unfair. For many years, it failed to take action. I'm afraid I don't believe I can take way because I've been told I have to proceed quickly. For many years, it failed to take action before clamping down purely on taxpayers and doing little to nothing to the enablers of this form of tax avoidance. And I hope the Minister now will be clear. He's talked about the promotion of defective schemes. When taxpayers are described as having done something illegal, which is what HMRC has said about the behaviour of those subject to the loan charge, why will this government not say that those who promoted those schemes also promoted something illegal? They use this language about defective schemes. I'm sorry, but that is pusillanimous. It's pusillanimous. We have to have a situation where those who unwittingly were led into schemes that are now described as illegal can themselves take action against those who wrongly advised them. So I hope that he will look at this very carefully. I hope that he will accept this amendment. If he doesn't, I hope that he will accept my backstop, to coin a phrase, and accept having a meeting with me. I'm glad that he intimated he might be willing to do that, to talk about this issue, to talk about how we can better help those people who've ended up in a very difficult situation, some of them with their eyes wide open, but many of them not realising the impact of these schemes. Thank you.
Review of the effectiveness of entrepreneurs' relief.
The question is that new clause 2 be read a second time. Nicky Morgan.
Thank you very much indeed, Madam Deputy Speaker. And I rise very briefly in this debate. I know time is short. Just to speak about new clause 26. Just the avoidance of doubt for the Treasury Front Bench, I won't be supporting the amendment, but I just want to put, as Chair of the Treasury Select Committee, just some concerns about the issue of the loan charge on the record on behalf of the many individuals who have contacted the committee and also on behalf of committee members who have expressed concerns on this. And I hope the ministers will listen and will engage with MPs across the House on this issue. We have raised as a committee concerns about the loan charge in evidence with my right honourable friend the Chancellor, with HMRC and with the Chartered Institute of Taxation. As the Honourable Lady said, it is right that people should pay their fair share of tax on their earnings, and we do not support anything that seeks to get around that. And it's right that HMRC should act swiftly and firmly to close those avoidance schemes down. But tax law sets out time limits within which HMRC can open inquiries and make tax assessments. And normally those tax time limits take account of whether a taxpayer has taken reasonable care to comply with their tax obligations, or has been careless, or has deliberately decided not to comply. And these time limits are seen as valuable taxpayer protections, giving a degree of certainty that takes appropriate account of taxpayer behaviour. And so it is concerning to, certainly to me, I'm not sure I can speak on behalf of the whole committee, but I think it's fair to say many of the committee members, that HMRC's contractor loan settlement opportunity requires people who want to put their affairs straight to waive those protections with the threat of the loan charge looming over them. It is not clear why it's necessary for that settlement opportunity to pressure people into paying tax for years which HMRC calls not protected. That's years where HMRC are out of time, even though they may have had the information they needed to open inquiries or raise assessments at the proper time. Yes, of course.
I'm grateful to my right honourable friend for giving way, and can I support the way in which she's addressing New Clause 26? And would she agree with me that although we want people to pay the correct taxes, and I find myself in a similar position to her on New Clause 26, that I have constituents that perhaps are facing losing their homes over this after they've entered into what they thought were perfectly legal and allowable arrangements, and that must be addressed by the Treasury.
Well, can I agree with my right honourable friend very much indeed. I think probably it will turn out that most of us have got constituents who are affected in this way. There are some who perhaps did know what they were doing. There are some who clearly didn't when they entered into these tax arrangements. I think it's absolutely right that correct tax is applied, but equally it is. I will honestly give way to the right honourable gentleman. It can't be right that people are facing serious situations which will undermine their financial security, but also even their mental health. I give way.
Yes.
Is she also aware that not only did quite a few people take advice, but they notified the revenue of what they were doing, and no objections were made at the time?
Yes, I absolutely agree with the right honourable gentleman, and I think this was raised in the Westminster Hall debate, led by my fellow committee member and my honourable friend, the member for Wickham as well. So let me just say this to the Minister. I think it is troubling to hear that tens of thousands of people who want to settle with HMRC before the 5th of April deadline have yet to receive calculations from HMRC. It is impossible, I think it would be impossible for most of us to settle large bills within a matter of months if we did not know what we were being asked to pay, let alone starting to make arrangements for how we might pay that. So they need to know, these individuals, how much they have to pay. And it is also, I would ask the Treasury Ministers to make it clear, to perhaps step in and make it clear what will happen to those people if they do not hear from HMRC by the 5th of April. I will leave that with ministers. I hope that they can tell there are MPs on all sides who are concerned about this. And I think that by working together, we can make sure the right tax is paid, but people are also treated fairly.
Kirsty Blackman.
Thank you very much. I'm aware that we're fairly short of time, so I won't rerun many of the things that I said in the committee stage. I'm sure the Minister will be delighted to hear that, and also the opposition front bench. Just a few of the amendments that we've got down in this section that I wanted to highlight to the Chamber. We have a couple of amendments asking if what the government is intending to do will do what it intends, once again. So looking to review the changes to entrepreneurs' relief, for example. Also looking to look at the emergency vehicles that there are and the changes that there are to emergency vehicles. We're particularly concerned about the potential rural impact that there may be on this, because those people who have emergency vehicles in rural areas may have more cause to use them outside work time than those people who are using them in the cities. And actually we felt like there was not enough drawn out about that in the previous stage, nor in the information that the government provided previously. New Clause 17 is about Brexit analysis. It's important to note, Madam Deputy Speaker, that since the Brexit vote in June 2016, over $1 trillion has been pulled from UK equity funds since that. And I think that's a really, well, it's obviously a really large number, but I think that's a really, something that the government should be noting in any changes that it's making, in any preparation that it's making in relation to Brexit, is the impact on the economy, which apparently, according to the Bank of England, has cost individual families £900 each so far, but also the impact on financial services, for example, that have historically been very strong in the UK. New clauses 15, 11 and 14 again ask the government to provide information around consultation reports, which is important that the government tells us the consultation that it's done on the draft clauses that it brought forward and the ones that it didn't bring forward as draft clauses. Why didn't it bring them forward as draft clauses? Just on that, I want to mention the fact that the government has got a new schedule in this bill, which seems to me to be a relatively unusual thing for the government to do at this stage, given that they could have either had it in the original bill or they could have had it in the committee stage, brought forward at that stage. Because the new schedule wasn't brought forward at the initial stages, the explanatory memorandum that's been provided by the government doesn't include the details of that new schedule, and it would have been helpful if it had been brought forward at an earlier stage, or if the members who had sat through the Bill Committee had been notified that that new schedule was likely to come, because presumably the government knew about it before the Christmas recess, and it didn't just appear out of the ether. So I think the process could be improved in relation to that. But the main thrust of what I want to talk about in the short remaining time that I have is about the changes that are made to the removal of the link between the personal allowance and the minimum wage. I understand the government has removed the link between the personal allowance and the minimum wage on the basis that the personal allowance has now reached £12,500, which means that the government doesn't believe that it needs to keep that link in there. And I understand that they're making that rationale, but actually, in terms of protection for people and in terms of protection from what any future government may do, if that link had been kept in there, that the government required to do a review if the personal allowance threshold was set at less than £12,500, then future governments would have continued to be bound by that, which would have meant that that level of protection that the government felt that was necessary for people on the lowest incomes, that level of protection would have still been there in the future. I understand that this government doesn't intend to reduce the personal allowance, but that protection could have been left in there without the law causing any problems as a result. So that's something that I'm concerned about. It's particularly concerning when the living wage that the government has put in place is not a real living wage, it's a pretend living wage. And it also doesn't apply to anybody who's under 25, which is an issue that the SNP has raised over and over again. Just because you are 24 does not mean that your living costs are less than because you are 26. You could have the same number of children and be living in exactly the same accommodation, but the government believes that it's okay to pay you less just because you are under that age threshold. And that's exacerbated by the fact that the increases in the minimum wage that the government has put forward this year increase as to a higher percentage, not just a higher monetary value, a higher percentage, the minimum wage that is received by those people who are over 25. So the gap is widening. They are getting a bigger increase in their minimum wage if they're over 25, and a smaller increase for the younger age groups. And I think the government really needs to take seriously the fact that they are saying that apprentices are worth pennies, frankly, and that 16 and 17-year-olds are worth far less than people who are under the age of 25. So this is something that we have raised our concerns about. We raised our concerns, I'm fairly sure, in the report, in the Committee of the Whole House stage, in relation to the removal of this number. And actually, I think it wouldn't have cost the government anything to leave this link in order to protect future generations coming through.
Thank you very much, Madam Deputy Speaker. I wanted to have a longer time to be able to say what a great job the government's been doing on a 43-year low for unemployment rates, 1,000 jobs a day created, and bringing in the personal allowance upgrade even earlier, but we haven't got time to go through all that. But I do believe getting people in work and getting them out of poverty is the way forward for many families. And the government was absolutely right to target business rates as a way of helping the high street and small businesses, with a cut of 33% in rates for businesses with a rateable value of under 51,000. But in areas like mine, with high property values, they're not having the impact that Chancellor might have hoped for. That this new rate simply provides a cliff edge that penalises successful businesses in areas that are plagued by high property values. And so we must devise a system that helps small businesses and pubs thrive, and not just those with low retail values. Now, I recently met with pub owners in my constituency that have been hit extremely hard by business rates, and I am pleased, because I can cut out an awful lot of my speech, to say I've got secured a Westminster Hall debate on this matter next Tuesday, where I look forward to exploring the matter further with the Minister who might be answering for me, because for pubs in areas like St Albans, they are just having massive hikes in business rates and not the help that was intended. But because time is pressed, I want to touch on the new Clause 26 that's been tabled by the Honourable Member for Kingston and Surbiton. I have serious concerns about this policy and the apparent retrospective nature of the tax being collected. Now, several of my constituents have raised their cases with me, and I'm extremely concerned about how this process has been handled. Many make the case that this was not illegal tax evasion. They were being advised to use this as a way of keeping more of their own money. And it's worth remembering that these people are not employees. They take on more risk with no sick pay, maternity pay and other forms of support offered to an employee. And I just want to give a couple of personal examples because I think this is key and we've got so little time. One of my constituents worked as an IT professional in the fintech industry, is being pursued for $900,000 by HMRC for the loan charge. He's extremely worried. Many are on the brink emotionally, and this has put him under considerable stress, and his family, when he was advised and he considered what he did was lawful. He's told me, worryingly, that he's tried to settle this case with HMRC for around $700,000, but this has been rejected. May I say there are many people who find themselves in tax difficulties who manage to make negotiated settlements with HMRC, and it appears to me that these particular group of people are being treated very unfairly and being left in a very difficult situation of not knowing exactly how much they owe, how quickly they've got to pay it.
On that point, will you give
briefly?
Thank you very much. Very generous. We're very short of time. Other colleagues are aware that the oil industry had a lot of contractors who were using what effectively has turned out to be disguised schemes. And would she agree with me that it's really HMRC's duty? We've heard today from another honourable member that customers shouldn't be unduly done by or disadvantaged if they haven't managed to settle their claim to date, because after the 5th of April it's going to be significantly more.
Exactly. And also, I've been advised by a former constituent who, despite no longer living in the UK, is being pursued by HMRC for thousands of pounds of unpaid tax. And again, another person who was advised that this mechanism truly was lawful, and this has come as a huge shock to his financial planning that he is left in this position. There is a reported over 100,000 people being pursued for unpaid tax. Now, no one's disputing people should pay tax that is due. But the way this has been requested and the manner in which they have been so badly advised and the way that they have never been able to check out that if anything they were doing was illegal because they were being advised it wasn't illegal at the time and it's a loophole that's now being closed has sent the attack dogs. It's going to have to be very quick because I'm aware other people need to speak.
I thank the honourable lady for giving way. She's making a very, very valid point, and certainly one of my constituents was actually advised, he was an IT contractor, was advised by his own accountant to take out this loan charge action. So actually a review would be very helpful on actually making sure these people get the proper advice so the laws can be followed and taxes collected.
Well, he's exactly right, and there are many versions of that story. I mean, I've had constituents who say the HMRC was made aware of these arrangements and no objection was raised until many years later. Now, that has got to be fundamentally wrong. What more due diligence can any member do? So I'm going to give way, because I know soon the honourable gentleman wishes to make his points. And I've been told the huge pressure and distress, even suicidal thoughts that this has put in the minds of people is totally unacceptable. And if we do nothing tonight, Minister, can we accept this new clause? There is a clear ambiguity over the law relating at that time. Maybe not now, maybe clarity is being sought now, but at that time, the fact that people cannot negotiate a reasonable settlement given that they acted in good faith at the time and are now being pursued to the point of destruction of their careers, their homes, their family lives, their marriages is completely unacceptable. This review is clearly something that needs to take place, and I hope the Minister will take that on board today and accept new clause 26, and if it's put to the vote, I shall vote for it.
Sir Edward Davey.
Speaker, can I thank the Honourable Lady, the Member for St Albans, for her passionate speech, and indeed the Right Honourable Lady, the Member for Loughborough, the Chair of the Treasury Select Committee, and indeed Right Honourable Members from around the House who have campaigned as a Parliament against this measure and have supported the new clause that I've tabled. And I would like to bring to your attention, Madam Deputy Speaker, my wish to divide the House on this new clause if the Minister does not accept it in his response. In addressing new clause 26, I want to make crystal clear from the start that I support the Treasurer's aim of closing tax loopholes and stopping tax avoidance. The introduction of loan charges in the 2017 Finance Act to stop future abuse was correct. And the review my new clause proposes does not seek to prevent the Treasury stopping this abuse from 2016, the budget announcement when the Finance Act was considered. Instead, somewhat inelegantly, due to the rules of finance bill debate, new clause 26 aims to focus the minds of Treasury ministers on the gross unfairness of how the 2017 Finance Act went about closing an unacceptable tax loophole. The review envisaged in new clause 26 will, I believe, reveal the unfairness of the retrospective nature of the current loan charge legislation, and do so in two ways. First, it would show how this retrospective nature is even more severe than non-retrospective but backward-looking proceedings for the recovery of lost tax elsewhere in our tax legislation. Second, it would show that the test of reasonableness included in the new section 36A, if applied to the loan charge, would in fact prevent any retrospective tax collection from the loan charge. But let me remind the House why the Treasury should then, after the review, ditch the retrospective nature of this measure, delaying April's implementation, and then amending the charge so it only focuses on payments made after 2016. It's because, Madam Deputy Speaker, the loan charge as introduced offends against the rule of law. It's the sort of taxation that led the barons to rebel against King John and gave birth to the Magna Carta. It is simply not acceptable for a government to introduce a law that makes illegal something someone did years ago when at that time that action was considered legal. It's a clear principle. I give way to the Honourable Lady.
I realise time is very short, and I thank the Right Honourable Member for bringing this amendment, which I also support. Would he not agree with me that it's unreasonable for people to be expected to have kept records going back 20 years when at the time they were reassured that this was a legitimate scheme?
The Honourable Lady is absolutely right, and thank her for support. Let's remember these people, our constituents, were given professional tax advice and behaved in a way that they thought was right and lawful at the time. I give way to the honourable gentleman.
I thank my right honourable friend for giving way, and I fully support the comments he's making and will be voting for new clause 26 if it comes to a division. I wonder if he would reflect briefly, though, on the concern I have that some people who support the government's position on this have implied that in seeking justice and fairness for our constituents, we are in some way condoning tax avoidance, when in fact the opposite is the case. We are saying that there should not be tax avoidance or evasion, but the real culprits in this are not the individuals who were conned and duped by professionals into taking out these schemes and who are now being faced with bankruptcy. The real culprits are the firms who designed and sold them these schemes in the first place, some of whom are still trading and operating today.
The honourable gentleman is right on all the points he makes. And if I refer to my honourable friend, the member for Eastbourne, who tabled the early day motion which got cross-party support when this campaign was getting going, those are exactly the points that my honourable friend was making. I think we all condemn tax avoidance and we support the Treasury, but this approach to retrospective taxation is simply unacceptable. And it is a fact, I give way to the gentleman, but now I must make some...
My honourable friend for the speeches that they've made, and wholly agree with them. And it is grossly unfair for someone who was a contractor between 2004 and 2006, one of my constituents, then to be expected to be recovering tax in this period. It goes against the whole principle of fairness and surely will not survive any challenge to the European Court of Human Rights.
Indeed, and it's simply a fact that HMRC has known about these tax schemes for years and took no action. These particular schemes were widely used. We've heard right honourable members from around the House have got constituents who've been affected. So they were widely used, widely advertised, and yet were ignored by the tax authorities. Can I just make some progress? People could only take some public sector positions if they agreed to be paid via these schemes. And it emerged ahead of the Westminster Hall debate that even some HMRC contractors were paid through such a scheme.
I'm really grateful to the Right Honourable Member for giving way and for bringing this amendment. I found HMRC's answers to this to the Treasury Committee wholly unsatisfactory. There remain serious questions to be answered of the promoters of these schemes, of the employers, including public sector employers who promoted these schemes to contractors, but also to HMRC. If people were given tax advice and followed it, if HMRC were aware of these schemes but didn't take action in any previous tax year, how on earth would any reasonable person conclude that they were doing anything wrong?
I totally agree, and I'm grateful for that intervention. Let me conclude, Madam Deputy Speaker. I cannot resist.
It's not often, as the right honourable gentleman knows, that I agree with him, but I do very strongly agree with him on this issue. Retrospective legislation is bad in principle. This is an unjust provision. It is unreasonable, it is unfair, and I do trust and urge the government to take note of the arguments that have been put forward.
Taking that wonderful intervention, I bring it to the attention to the House that the Honourable Member for Wellingborough has signed my amendment. So this is an amendment that is bringing the House together at a time when elsewhere it is divided. But let me end, Madam Deputy Speaker, on what this loan charge and its retrospective nature has meant for our constituents. It has caused misery.
Absolutely.
It has affected people's lives, their health, their families. It has caused gross misery. Some people believe they will have to go bankrupt if they are forced to pay, that they may lose their homes. And that is why I think the House is united against this retrospective action. And I really hope the Minister will get to his feet, accept this new clause tonight, go ahead with the review, bring it back before the end of this tax year so the House can see that review and then vote on it.
Madam Deputy Speaker, I rise to speak in support of new clause 2. I was staggered to learn that the entrepreneur relief cost the Treasury an estimated £2.7 billion to allow people selling companies worth up to £10 million to keep half the money that they would otherwise be paying in capital gains tax. I was even more surprised to learn that this tax relief is concentrated amongst the very few wealthy individuals, with 6,000 people making gains of over £1 million, averaging £450,000 in tax relief each. This relief is only benefiting the very wealthy and should be reviewed as to its effectiveness. If scrapped, the £2.7 billion could be used to fund schools which are buckling under the pressure of funding cuts, provide huge investment in special education needs and children and adolescent mental health needs. Could also go some way in funding children's services and social care in local authorities and policing. But this is not the only area in which the company is giving away money which could otherwise be put to better use. Under Amendment 22, in the name of the Honourable Member for Aberdeen North, the Government are being asked to review the expected effects of public health of the changes being made to the Alcoholic Duties Act 1979. The Alcohol Health Alliance have stated that the Government's own figures show that alcohol duty costs from 2013-14 have cost the Treasury £4 billion, which is the equivalent to yearly costs of employing over 100,000 teachers. This figure is expected to rise to £9.1 billion by 2024. Considering the pressure on budgets as a result of austerity, this is not an insignificant amount. The freeze on duty on beer, spirits and cider for 12 months from February 2019 is in effect a cut, as it is not in keeping in line with inflation and has not done so for 6 of the last 7 years. Cheap alcohol has a tremendous effect on causing damage to people's health, the economy and the wider society. Alcohol is the leading risk factor for death for 15 to 49-year-olds in England. In England alone, there are more than 1 million hospital admissions and 24,000 deaths related to alcohol every year. This is clearly an impact that the Government needs to consider when setting duty on beer, spirits and cider. Cuts to alcohol duty have the double effect of both reducing revenue for the Treasury, which reduces funding available for the NHS, while simultaneously increasing demand and costs within the NHS by encouraging consumption of cheap alcohol. I will therefore ask the Government to review the impact of the duty freeze on alcohol on public health. Turning to new clause 26 in the name of the Right Honourable Member for Kingston and Surbiton, when it comes to collecting taxes from individuals, the Treasury via HMRC have been brutal in their demands from contractors who are paid via loans. Let me be clear, I've got no time for tax dodgers and tax avoidance, and I believe that the disguised remuneration scheme was used by some people, including businesses, to avoid paying tax. But this is wrong, and tax avoidance should be dealt with severely. However, having met with a number of people at my local surgeries and heard their stories as to how they've been mercilessly pursued for alleged unpaid taxes going back over many years, it's clear to me that HMRC have adopted an approach of shoot first and ask questions later.
The Honourable Member give way. Thank you. I thank the Honourable Member for giving way. And will he agree with me that from the stories we hear from our constituents, some of these people are not only afraid of losing their homes and their living, but they're actually having suicidal thoughts due to the pressure that's being put on them to pay the money.
I was just about to come to that point, but she makes an excellent point, so I thank Madam Friend for that intervention. Whilst the large accountancy firms have gone unpunished for creating tax avoidance schemes for big banks, these individual contractors are bearing the brunt of HMRC's powers. I've been advised by the Loan Charge Action Group of suicides, bankruptcies and relationship breakdowns as a result of the stress involved in dealing with the HMRC. The Loan Charges Action Group advised that many of those being pursued by HMRC unwittingly sign up to loan-based schemes, and yet the promoters of these tax avoidance schemes have not been targeted. In conclusion, I would ask the Minister to reconsider these schemes and to make sure that people don't go punished when they shouldn't be.
Minister.
Thank you, Madam Deputy Speaker. And I think, given the very limited time that I have available to cover what has been a debate which has ranged across a very large number of amendments and new clauses, I shall just limit my remarks principally to the issue that has been debated most in this particular group this evening, and that relates to new clause 26. And, Madam Deputy Speaker, new clause 26 would require the Government to lay a report before this House reviewing the effect of changes made by clauses 79 and 80 no later than the 30th of March 2019. And whilst I should note that such a report will come too soon for the measures to have had a real effect, this Government of course remains committed to setting out the rationale for its policies as well as their impact, and in that spirit we will not be opposing new clause 26. But let me equally take the opportunity to echo many of the comments that have been made by honourable and right honourable members this afternoon as to what these schemes are truly about, which is gross aggressive tax avoidance. The way that the disguised remuneration, I will give way in a moment if I may, the way that disguised remuneration typically works is that instead of an employer paying an employee by way of a salary in the normal way, which attracts, of course, PAYE income tax, it attracts employers' national insurance, it attracts national insurance from the employer's point of view, the payment is actually made as a loan. And typically, in these schemes, honourable and right honourable members should be aware that these so-called loans, which are not really loans at all, there is no intention of ever repaying them, are routed out via an offshore trust in a low or no tax jurisdiction, and are then routed back to the United Kingdom to be received by the end recipient. And this is basically extremely unfair. It is unfair to our public services because we have a duty as government to collect the tax which is due to fund them, and it is unfair to the vast majority of taxpayers who do the right thing, which is to not get involved in these aggressive tax avoidance schemes in the first place and to pay their fair share of tax. One issue that has been raised on a number of occasions is as to whether HMRC's the loan charge arrangements are themselves retrospective. They are not retrospective in the critical sense, and this is where I do take issue with the right honourable gentleman, the member for Kingston and Surbiton. They are not retrospective in the sense that at the time that they were entered into, they were defective, these schemes. It doesn't matter how far you go back, the scheme, typically, which I've described the way that it works, was defective at the time. It didn't work then, it doesn't work now, and the tax is due. And what I would also say is that these schemes have been taken through the courts on many occasions. These schemes, a scheme also operated by, used by, to the benefit of Rangers Football Club, was taken to the Supreme Court, the highest court in the land, and the scheme was found to be defective. But I will, I won't give way simply because I have 2 minutes and 30 seconds, and I do want to cover some of the other issues that were raised this evening. But as I have said, we will, as a government, accept this new clause. It is absolutely right that when HMRC deals with the public, that they have a strict duty of care, they have a duty of proportionality, they have a duty to be as sympathetic as they can be, relevant to the circumstances of those with whom they are dealing. I have, in my dealings with HMRC, made those points most forcefully clear. HMRC have recently, as the right honourable gentleman himself will know, come forward to say that for those earning £50,000 or less, which is over twice the average national salary of somebody working in our country, that they will automatically be granted, without a requirement for additional paperwork, a minimum of 5 years' time to pay as an arrangement to settle their affairs. And of course, for those who come forward before April, There is effectively, in most cases, no penalty as such. They will simply be required to pay that tax which was due in the past, and it was always due in the past, plus the interest that is rightly applied. I have less than a minute, and I do want to very quickly say a little bit about the Honourable Lady, the member for Aberdeen North, and her clause Amendment 12 in relation to the national minimum wage lock. She will know that because we have actually increased the personal allowance now to £12,500 for every year of the forecast period, it will be the case that there is no necessity for that lock to be in place. She makes the point that it could be a projection beyond that point. Well, that will be a matter, of course, for a future government, and is not for this Parliament to bind its successors. And I conclude with the suggested entrepreneurs' relief review. This is new clause 2, and the Honourable Lady, the member for Oxford East, spoke to that, and to say that we did have a review that was published in December 2017, which reported on just this particular matter. And what that showed was that a third of those using entrepreneurs' relief went on to reinvest in new businesses. Half of those who were aware of entrepreneurs' relief said that it did influence significantly their decision to enter into an entrepreneurial activity. It is a very important element of the business tax landscape, and we will, of course, as we do with all taxes, keep that particular relief under review. And with 6 seconds left, Madam Deputy Speaker, I urge that, with the exception of new clause 26, that the House accepts the government new clauses and rejects the opposition's amendments.
The question is that new clause 2 be read a second time. As many as are of that opinion say aye. Aye. Of the contrary, no. No. Division, clear the lobby.